Davis, are you appointed to review this matter?
Retain, Your Honor.
So you both decide for a moment. It's criminal record. Well, I take note of a number of defaults that extend for a period of years on a number of the prior larceny-related charges, each of which I would note were dismissed upon payment of restitution and court costs by the defendant. That would be 6 different criminal cases with 10 larceny-related charges in total. I am satisfied with regard to her walking into court today with Attorney Jay Davis that it is not necessary at this time to request a cash bail be set. However, Commonwealth is requesting, which I believe are agreed, conditions of release as to Ms. Enos. Those 2 conditions being that she is to stay away from and have no contact of any sort, including internet or text messages, with the family of Casey Pittman. That includes Casey Pittman, the young man with muscular dystrophy that the fund was started to benefit, which is the subject of this case, as well as his parents, Connie and Paul Pittman. In addition, Connie Pittman, her Aunt Lydia Conker, who was the individual that initially contacted the district attorney's office to bring his concerns of the family to the attention, which resulted in an investigation by the district attorney's office of the grand jury and the indictments that brings the defendant before the court. The second request for a condition, Judge, condition of release for this defendant is that the $7,566, which appears to be from the review of the bank records and the review of the expenditures that did go to the benefit of Casey Pittman's case, appears to be the missing one. Attorney Davis contacted me, advised in June following the indictments that Ms. Enos had reportedly secreted the approximate $7,600 of missing money into a bank account to keep it safe so that it wouldn't be misused by the family. In a nutshell, Judge, the allegation here is that back in 2006, a charitable fund was set up for the benefit of Casey Pittman, a young man who was 11 years old at the time, today he's 15, suffering from muscular dystrophy, to assist the family in purchasing an electric wheelchair, which he was in need of, and other needs of arising as his disease progressed. The allegation, Judge, is that pursuant to what's indicated in the bank records, that approximately 4 months after the account was opened in March of 2006, and unbeknownst to anyone, except for the defendant before you, who was the sole name on the Casey Pittman fund account that was set up at the community bank in Rockland, that account had been spent down, bled dry from approximately $23,000 down to $4.05, which remained for the following 4 years. In the course of the family requesting expenditures from that fund for the benefit of their son, as there was monies left over after the wheelchair was purchased, they would make requests, Pittmans would make requests to the defendant, who would then consider the family's request for uses, allow some of those requests, deny others, and she resorted to a friend of hers, a woman named Kathleen Brissett, who is a business owner at the Tedeschi's on East Ashland Street in Brockton, where she reviewed Pittman family's requests with Ms. Brissett to determine if those requests would be accepted. By 2009, according to the grand jury investigation, Casey Pittman's condition began to deteriorate further, and the family was concerned that they'd be able to access the monies to use those monies for the benefit of Casey. His time was considered to be precious at that juncture. When Lydia Conker, who was designated by the family as the spokesperson to request access to account balance information and bank statements for this Casey Pittman fund, those requests were allegedly rejected by the defendant, who after failing to return phone calls was gotten on the phone by Ms. Conca and is allegedly hung up on her, prompting the family to come forward to the Brockton Police Department District Attorney's Office, again prompting this investigation. The Brockton Police, in March 2010, went and interviewed the defendant before you, Ms. Enos, at her home. They were invited into her kitchen, and they asked her questions about the status of the Casey Pittman Fund. And they were told by the defendant, allegedly, that the fund was still in effect, that there was a balance of $7,566 still in the Casey Pittman Fund account that had been set up in March of 2006, and that essentially there was nothing wrong and nothing untoward going on with the monies. Subsequent to that interview, the grand jury subpoena of bank records allowed the Brockton Police and the District Attorney's Office to review the records. And it was then determined, in fact, that only 4 months after the account was opened, by June of 2006, the account, they said, was down to $4.05. And that, in fact, 5 weeks prior to that police interview at Ms. Enos' home, where she represented that the account was still viable and contained approximately $7,600, in fact, that account had been closed 5 weeks earlier, having had a negative balance, and having been closed on February 2nd, 2010, as corroborated by bank surveillance photos of Ms. Enos herself conducting that final transaction with the Casey Pittman Fund. It is now...
well, did the Commonwealth trace transfer and movement of those funds?
Essentially, Judge, what the bank records show is that there was never any transfer of the funds as alleged of $7,566 into there was never any withdrawal in that amount because there was no such amount of money in the account for over the last 4 years. Furthermore, Judge, with regard to the investigation, revealed that Ms. Conca, after the Pittmans had come to the District Attorney's Office and come to the police department, had even gone to her assistant in overseeing the Casey Pittman Fund, Kathleen Brissett, the Tedeschi's shop owner on East Ashland Street. And in sworn testimony before the grand jury, Ms. Brissett identified documents that she had been given in late January 2010, a time when that Casey Pittman Fund was in a negative balance. Documents which a keeper of records from the community bank identified as from his knowledge of the font on the website and from his knowledge of the actual balance of that account had been doctored by Ms. Enos and provided to her own friend. The defendant further, Your Honor, in the police interview advised them that she had no ATM card for the Casey Pittman Fund. She had no checkbook for the Casey Pittman Fund. And in fact, in review of the records, it is revealed, Judge, that there were, as an example, one 2-week period in January of 2010, prior to the account being closed out, approximately a week later, that there were 46 different ATM withdrawals in a period of 14 days at convenience stores in the city of Quincy and the city of Brockton, to amounts of approximately $41. Occasionally withdrawals of $100, $61, multiple withdrawals on many of the days within that 2-week period. With regard to the condition of the second condition of release that I requested, counsel's advised that he has no objection to that. He advises.
What is the request?
The request is that the $7,566 be turned over immediately to the Brockton Police Department. That was money that was donated by the residents of Brockton for the benefit of Casey Pittman. And the police department and the district attorney's office will safeguard those monies until this matter is resolved and until a appropriate account can be arranged so that those funds can then be accessed for Casey's benefit. As I indicated, as his disease explained by the fact that the money had been converted or secreted with an intent to convert that money from the Casey Pittman Fund for her own use. I think the facts that I've just summarized speak for themselves as to her willful misleading of the police as they attempted to investigate this offense, lying to them about her possession of an ATM card, lying to them about the fact that she represented the Casey Pittman Fund still existed, lying that there was $7,566 still in that account, just as she lied to Pittman's, just as she lied to her own assistant, Ms. Brissett.